Hey everybody, welcome to another episode of Foreclosure Help 777, where we talk about everything foreclosure related. As always, guys, thank you for joining me on my channel, and if you've subscribed and hit the like button, I appreciate that. And we have our private Facebook group here of 246 members right now. We are all in it together, fighting for our homes. And as you know, I fought for my own foreclosure back in 2011 to 2021. So a lot of us have been fighting a really long time, and we have a lot of experience that we can share with others who are maybe new to the game and might need some help. Today we're going to talk about quiet title actions and what these are and why people file them, and some tips. And let's go right away to ChatGPT, where I asked the golden question to Chat. I said, what are some good tips for a pro se homeowner that wants to file a quiet title action against their mortgage servicer? And then ChatGPT says, filing a quiet title action pro se can be very challenging, especially against a mortgage servicer, because courts scrutinize these cases closely and servicers usually have strong defenses. That said, there are some practical tips to help a homeowner prepare and avoid common pitfalls. Understand what a quiet title really does. A quiet title action is meant to resolve disputes about ownership of property or competing claims to title. It is not just a way to get rid of a mortgage. The homeowner must show that the mortgage assignment or lien is void, not merely voidable. Courts generally won't use quiet title to erase a valid loan simply because of a bad servicing or collection practices. Identify a clear legal defect in the chain of title. Quiet title cases succeed only if you can point to a concrete documented defect, such as a void assignment executed by a defunct company, robo-signed with no authority, or after the assigner ceased to exist, a forged, altered, or fraudulent document recorded against the property, conflicting recorded interests, two different parties claiming ownership, beneficiary rights, a lien that is time barred by statute of limitations in your state, satisfaction of mortgage not properly recorded, lender claims debt still exists when it was actually paid or discharged. So these are some things that I guess we can talk about further, because they're very important that you, when you file your quiet title action, that you have good reasons. And then it says here to do a thorough title search. Okay, pull the grant deed, deed of trust, mortgage assignment, substitute of trustee releases, and foreclosure notices from your county recorder's office, your recorder of deeds office. Compare the timeline. If an assignment was recorded after the trust closed, after the lender ceased to exist, or with glaring errors, highlight that. Courts want to see recorded evidence, not just allegations. Plead specific facts, not conclusions. Avoid vague statements like the assignment is fraudulent or the servicer has no standing. Instead, plead facts. The assignment dated January 10, 2015 was executed by XYZ as attorney in fact for ABC Bank. However, ABC Bank was dissolved in 2012, and therefore the assignment is void ab initio. And that means from the beginning, by the way. Cite statutes and case law from your jurisdiction supporting why a void instrument cannot convey title. Anticipate the servicer's defenses. Anticipation is always a good idea. It's just like a chess game. Know your opponent's moves before they make them. Mortgage servicers almost always argue, you lack standing. You still owe a debt secured by property, so your interest isn't superior. Assignments are valid, or at least voidable, not void, and only if the original parties can challenge them. You received the loan funds and signed the note or deed of trust, so you cannot use a quiet title to erase the lien without paying off the debt. Judicial estoppel, res judicata. If you raise these issued in bankruptcy or a prior foreclosure case, you cannot bring them up now. These are some things that the servicer will use as a defense to your complaint. Be prepared for the tender rule. Many courts require that a borrower tender the full amount due before seeking to quiet title against a mortgage holder. Some exceptions exist. If the lien is void rather than voidable, or if the debt is time-barred. Research your state's case law carefully to see if tender is required. Structure your complaint properly. Typical sections include parties and jurisdiction, factual background and chain of title, cause of action for quiet title, relief sought, and there's actually more to it than just this. AI is not giving you all the answers here. A properly structured complaint has many other things that are just as important as these. Let me tell you that. Attach certified copies of your deeds, assignments, and relevant filings as exhibits to support your complaint. Consider additional claims. Quiet title often works better when paired with wrongful foreclosure if a sale has already occurred. Declaratory relief to establish rights and duties under the recorded instruments. FDCPA, FCEUA for collection violations. These guys are debt collectors. They violate the FDCPA if they try to collect on a debt where they don't have standing to collect on that debt. Fraud or forgery, again, it has to be backed by hard evidence. It's hard to prove fraud, so you got to make sure you have real hard evidence of the fraud. Check state-specific rules. Quiet title law varies significantly by state. For example, California has strict on-tender rule and standing to challenge assignments. Texas has a 4-year statute of limitations on enforcing liens can bar foreclosure. Pennsylvania has quiet title. Pennsylvania quiet title requires proof of superior title, not just defects in others' claims. Know the risks. If the case is frivolous or unsupported, courts may dismiss it quickly and can even award attorney's fees to the servicer. Servicers often remove quiet title cases to federal court if you mention federal law, which can raise costs and complexity. That is something that they do. They do take them from state to federal. And then they try to get them dismissed in federal court. Bottom line, a strong pro se quiet title case requires hard documentary evidence of a void lien assignment, clear pleading, and anticipation of defenses like tender and standing. Without this case will risk dismissal. Now it's asking if would you like to draft a quiet. You got to be careful. AI or ChatGPT will always ask you, do you want this? Do you want that? Even if you've already have it drafted, it'll always ask, do you want more stuff? And sometimes the answer is no, you do not want more stuff. So beware of that. Okay, so the next question I asked Chat is, what if the servicer, say, is PennyMac and they claim to be the mortgagee, but the promissory note is stamped in blank and does not show PennyMac anywhere? Also, no assignment was ever recorded from the original lender to PennyMac. That fact pattern is exactly the kind of issue that a homeowner can use to frame a quiet title challenge, but it has to be handled carefully because courts draw sharp lines between possession of the note, Article 3 UCC issue, who has the right to enforce the note, ownership of the mortgage deed of trust, who holds a valid recorded lien. Here's how those facts could play out in a pro se homeowner's quiet title action against a servicer like PennyMac. Number 1, blank endorsement equals bearer paper. If the promissory note is endorsed in blank, it becomes bearer paper under UCC Article 3. Whoever physically possesses the note can enforce it, the holder. PennyMac might claim it is the servicer in possession of the note and therefore the mortgagee under state foreclosure law. But mere possession of a note doesn't automatically fix defects in the chain of title to the deed of trust or mortgage. Recorded assignments versus note possession. Mortgages and deeds of trust are generally inseparable from the note. The lien follows the debt. However, courts usually require some evidence of how the lien got from the original lender to the current claimed mortgagee. If no assignment to PennyMac was ever recorded, your assignment is the public record does not reflect PennyMac's interest, so their lien is defective or unenforceable as a matter of title law. Quiet title framing. To state a viable quiet title claim, you'd want to allege, number 1, you are the record owner by deed. PennyMac is claiming an adverse interest mortgage lien. PennyMac is not named in the note, only a blank endorsement, and has no recorded assignment of the mortgage or deed of trust. Therefore, any claim they assert is invalid and clouds your title. Courts often push back here. They will say the note follows the mortgage and a blank endorsement possession is enough to enforce. That's why your complaint must emphasize that without a recorded assignment, PennyMac cannot establish an enforceable lien in the land records, which is what a quiet title action is meant to resolve. And then you have this tender rule obstacle. Many states apply the tender rule. You cannot quiet title against a lien holder unless you pay or offer to pay the underlying debt. But some courts carve exceptions where the lien is void ab initio, which means from the start. Forwards assigned by a defunct entity and not recorded at all. You need to frame it as a void interest rather than an unenforceable or defective one. And then here's some supporting case law, guys. Ivana versus New Century, which is a California case where the borrower has standing to challenge a void assignment in a wrongful foreclosure quiet title case. U.S. Bank versus Ibanez, Massachusetts, 2011. And by the way, that is also a YouTube video somewhere if you wanted to watch that one. Foreclosure void where assignments into trust were not validly executed before foreclosure. Montgomery County, PA, Recorder versus MERS. The Pennsylvania emphasizes assignments must be properly recorded to preserve a chain of title. These support the principle that lack of recorded assignment can render enforcement invalid, though results vary by state, and that is so true. And the last thing we're going to go over with here is strategic considerations. A bare argument that PennyMac's name isn't on the note will usually fail because blank endorsements do give enforcement rights. A stronger strategy is to say, attack the lien's record chain. Show that no assignments to PennyMac exist in the land records. Argue that this creates a fatal defect in their claim to be the mortgagee of record. Demand judicial declaration that any purported lien by PennyMac is void and that the title vested solely in you. Okay guys, I hope this has been informational to some of you that are dealing with trying to decide if you should file a quiet title action or a verified complaint in court. A lot of us have mortgages that have clouds on our titles, and we really want to find the right remedy, and suing your lender is definitely one way to do it. If you have any questions, you can send me an email. My email address is right here, foreclosurehelp777@gmail.com with the number 4 as you can see here. And if you have any comments, leave them, and I will be happy to answer any questions you have. And as always, everyone, have a blessed day.